Huh?
Good evening, everyone. And on behalf of Beyond Law CLC, we welcome Mr. Venkatasudharshan, who is the retired Principal District and Session Judge, Bengaluru, wherein he has, as we had said earlier, he would be taking us to the entire sessions of the Transfer of Property Act 1882. Two parts we have already done. Those who have missed on Beyond Law CLC, they can watch them. They're available. And today we are taking the third part, wherein we go into the deeper dives of the introduction to the basics. Over to you, sir, and thank you for accepting our invite.
Thank you very much, Mr. Venkatasudharshan, sir. Welcome to all viewers. This is the third in the series on the topic of Transfer of Property Act, a very important enactment. In the previous two sessions, we have seen the significance and importance and meaning of the preamble portion of the Transfer of Property Act and discussed about the definition, some of the definitions of some of the important words and phrases like what do you mean by an immovable property? What is an instrument? What do you mean by attested, registered, notice, etc. Now we are moving on to the second chapter of this Transfer of Property Act. Second chapter deals with a very important part of the Transfer of Property Act, that is, of transfers of properties by act of parties. This chapter has got two parts. Part A of chapter 2 is from section 5 to section 37, which deals with transfer of property, whether movable or immovable. Part B of this chapter, which deals with only immovable property, from section 38 to 53. So, a conception that Transfer of Property Act is applicable only for immovable property may not be correct. Certain portions of the Transfer of Property Act, particularly from section 5 to section 37, are applicable both for movable and immovable property. And section 38 to 53 of chapter 2 are applicable for immovable properties. In part A, section 5 defines what a transfer of property is. According to this section, a transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself. And to transfer property is to perform such act. The careful reading of this particular section shows that it involves 5 important ingredients. It is an act of parties by which one living person, that is a natural person, a human being, let us say to start with, who is called as a transferor, he conveys property which is in present, property in present or in future, conveys in present or in future to another living person or to himself. So these are the 6 important ingredients which are found in this section 5 of the Transfer of Property Act. After this definition, A living person has been explained within the brackets. It is stated like this. In this section, living person includes a company. So a living person does not necessarily mean a natural human being or a natural person. It includes a company or association of body or association or body of individuals, whether incorporated or not. So when we are using the word living person here in this section, it does not necessarily mean a natural human being, a natural person. It includes a company also, because company is a juristic person, or a body of individuals, or an association, whether incorporated or not. Let us pause for a while here and go back to the preamble again. The preamble portion of the Transfer of Property Act says that whereas it is expedient to define and amend certain parts of law relating to transfer of property by act of parties. So by using the word act of parties, it means that there is a plurality, a transferor and a transferee. So the Transfer of Property Act is applicable when there is a conveyance of a particular property, conveyance in present or future of a particular property to one living person, to another living person. Living person includes a natural human being or a company or a body of individuals or association, incorporated or not. So when we use the word act of parties, that means transfer of property is not applicable where there is an operation, where there is a transferation by operation of law. In this context, it may be useful for us to refer to the decision of the Honorable Supreme Court reported in AIR 2004, Supreme Court 2206, in Bharat Petroleum Corporation Limited versus Keshavan, wherein the Honorable Supreme Court has said, the provision of the Transfer of Property Act have no application in a case where transfer is by operation of law. As would appear from preamble, the Transfer of Property Act, the same applies only to transfer by act of parties. A transfer by operation of law is not validated or invalidated by anything contained in the Transfer of Property Act. A transfer for which takes place by operation of law, therefore, need not meet the requirements of the Transfer of Property Act. So by this, it is very clear that where there is a transfer by operation of law, the provisions of the Transfer of Property Act is not applicable. And the Transfer of Property Act is applicable only when there is a conveyance in present or in future in respect of a property from one living person to another living person. Thus, it is an activity. Transfer of property is an activity or a process. Under this activity, one person called a transferor, by his act, does some act by which he conveys the property to another living person called as a transferee. As I have already explained, that a living person includes a company, association of persons, body of individuals, incorporated or not. In this context, we may refer to one more judgment of the Honorable Supreme Court. Reported in AIR 1986 Supreme Court, page 368. Which deals with the meaning of the word act of parties. Living person, it is a transfer between one living person to another. As already stated above, the living person may be a natural person or a company or an association of individuals, but the person transferring the property must be alive at the time of transfer. This is very, very important aspect to be considered. The only requirement is the person should be competent to contract. So who are all the persons competent to contract? Has been explained in the Contract Act itself. A minor, a lunatic, a person of unsound mind, or insolvent, or the persons who are not competent to enter into the contract. So therefore, they cannot be considered as competent persons to transfer the property. So there must be a transfer by a competent person. A person who is competent as per the terms of the Contract Act. So he should not be a minor. He must be a person of a sound mind. And it should be without any coercion, undue influence, fraud, etc. Transfer of Property Act, since it applies only to a voluntary act of transfer of property, from one living person to another, transfer of property does not apply to property sold in auction. So when a property is purchased in an auction by X, it will not come under the meaning of the Transfer of Property Act, because that is not a voluntary transfer. And there is no transfer from one living person to another living person. This is covered by AIR 2001, Allahabad, page 334, Krishna Mohan versus Balakrishna. Then, meaning of the word conveys. What do you mean by the meaning of the word conveying? Because if you go back to the definition, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself. So conveyance means it is a doing an act called transfer. It is doing an act called transfer by which a transferor creates a new right. Transferor, by transferring a property, creates a new right in favor of the transferee. And the transferee get interest in the property on transfer. So the test as to whether transaction is conveyance or not is whether the transaction passes and creates certain new rights in the process, some right from the transferor to the transferee, and creates some new right in the transferee. This is another important aspect to be kept in mind. Here, the word present or in future is used. The word present or future used here does not apply to property. It applies only to the conveyancing. Normally, transfer of property must take an immediate effect. When I am selling the property by executing a sale deed, the right, title and interest in the property should simultaneously pass on to the transferee when I am executing a sale deed. That is, property must be existing. So here, the word present or future does not apply to the property because the property must always be existing at the time of transfer, but it applies only to a conveyance. Conveyance of title may be either present or in future. Conveyance of interest may be either present or in future. So normally a transfer of property must take immediate effect. Sometimes it may take effect on a future date. A person is free to transfer property upon fulfillment of certain conditions. So therefore, the word conveying used in section 5 of the Transfer of Property Act refers to the word present or future used in transfer of section 5 of the Transfer of Property Act refers to conveyance and not to the property. Then the definition of the meaning of the word property. Property has got a very wide meaning. It has got very wide description. It could be either movable or immovable. A property is essentially a bundle of rights and interest. If I am the owner of a particular property, if I own a particular property, that means I am the owner, I am the title holder, I am the person having interest in the property, I am having a person having right over the property, and I am the person who is in possession of the property. Possession could be either physical or constructive. So all these incidents were called as bundles, bundle of rights and interest in the property. All these signifies ownership. So when we call a particular person as a owner, when he has right, title, interest, and possession in respect of that particular property. As I have already stated, the word present or future refers to the conveyance or the transfer and not to the property. This is covered by two decisions. One is AIR 1955 Supreme Court, page 376. And another one is AIR 1968 Madras, page 319, a full bench decision of the Honorable High Court of Madras. That is Chief Controller, Revenue Authority versus Sudarshan Pictures. The transfer of a non-existent or a future property amounts only to a contract which may be performed on a future date. Then the meaning of the word to another living person or to himself. The word transfer from one living person to another living person is understandable because the person to whom it is going to be transferred is either a natural human being, natural person, or a company, or an association, or a body of individuals. But the word himself is used, it has got a great significance. What do we mean by this? How can a transfer of property be made to himself, by himself? How can I have the property transferred to me only? My own property be transferred to my name only. So that is explained in the following way. Let us say, for example, I want to create a trust. So when I want to create a trust, I become the author of the trust. First, I have to transfer my property to the trust. And that trust will receive the property through its managing trustee. So I myself become the managing trustee. So I will get the property, my own property transferred by me in my individual capacity to the name of the trust that is in my name as a managing trustee. So this is one such situation where a transfer of property refers to transferring of a property by one living person to himself. In this context, I may refer to a decision of the Honorable Supreme Court reported in AIR 1961 Supreme Court, page 1023, Tulsidas versus Income Tax Commissioner, and also another decision report of the Honorable High Court of Andhra Pradesh, AIR 1984 Andhra Pradesh, page 176, VP Rao versus Sri Ramanujam. So when we say that the Transfer of Property Act is not applicable in case of transfer by operation of law, some of the examples are a will, when a property is bequeathed under a will, a family settlement, partition, compromise, they are all by operation of law. And therefore, it is not by one living person to another living person. It operates by, it's a transfer by operation of law, for which the provisions of the Transfer of Property Act may not be applicable. So this is how, according to me, Section 5 of the Transfer of Property Act will have to be understood. As I told in the previous sessions itself, I am not going into the details of each and every topic, each and every aspect. I am just giving a broad outlines of that so that we can further research into the matter, investigate into the matter, and get more and more inputs by reading the commentaries on the subject. Then we will move on to Section 6. Section 6 of the Transfer of Property Act deals with what may be transferred. Though the caption of this section says what may be transferred, if we read the section, it makes a list of items which cannot be transferred. Let us have a look at the section. Property of any kind may be transferred, except as otherwise provided by this Act or by any other law for the time being in force. Now, what are all the things which cannot be transferred? A, the chance of an heir apparent succeeding to an estate. Number 1. Number 2, the chance of a relation obtaining a legacy on the death of a kinsman or any other mere possibility of a like nature cannot be transferred. I am drawing your attention to Clause A of Section 6. Clause A of Section 6 comprises of 3 parts. The chance of an heir apparent succeeding to an estate, number 1. Number 2, the chance of a relation obtaining a legacy on the death of a kinsman. Number 3, or any other mere possibility of a like nature cannot be transferred. Now let us have a discussion on each one of these 3 aspects which are covered under Clause A of Section 6. Chance of an heir apparent. This is number 1, spes successionis, mere right of re-entry, easement apart from the dominant heritage. That will come to that later. Chance of an heir apparent. Heir apparent is not a legal heir. Heir apparent is not a legal heir. He is apparently a heir. He would be a heir in future if he survives the propositors. That is, the property of the person whom he inherits. And if the propositors dies intestate. Let us take, for example, a case where there are 2 brothers, A and B. They inherit the property of their father in equal share. A is not married. Or if he is married, his wife is not there, not alive. He has no children. Now, if A dies, the chance of B being the brother, succeeding to the property is there. So though the chance of B succeeding to the property is contingent upon A predeceasing B. That is A dying, leaving B, leaving behind B. This is called as a chance of succession, a heir apparent. This is possible only when there are two situations. Number one, he must survive the propositus. In the example which I have given, if B survives and A dies, survives A, that A dies, then only B will get a chance of succession because A does not have any other legal heir, neither the wife nor the children. So the chance of B succeeding to the property is more. This is one situation. Number two, that the propositus has not left behind any will. He died intestate. So if he has executed any will, then the property belonging to A will go to the person, to the legatee under the will, a beneficiary under the will and not to B. So a heir apparent is one who is apparently a heir, but he will succeed to the property only when the propositus, that is the owner of the property, dies before his death. That too, without leaving a will. Supposing in the example which I have given, B dies before the death of A, then the question of B succeeding to the property doesn't arise at all. Let us take one more example. Father and son are entitled to inherit a property. The property of each other. If father dies first, son would inherit father's share. But if son dies first, he would not inherit the father's share. So the son will inherit the father's share only if the father dies first. Since who would die first is uncertain, it is not known whether father will die first or son will die first. Death is uncertain. Even son may die first, leaving behind his father. So because the death is not certain, the succession that son may have is only contingent upon the father dying first. So this is one example of spes successionis. Let us take one more example. A is the father. He is suffering from an incurable disease. An incurable disease. He has two sons, B and C, S1 and S2. During the lifetime of A, that is the father, B sells the half share of his father to C. Now the question is whether such a sale made by B in favor of C of the property belonging to A during the lifetime of A is valid. Absolutely not. Because B has not yet succeeded the property from his father at all. Father is still alive. Therefore, such a conveyance cannot be accepted to be a valid conveyance under law. So, this is one illustration which covers first part of A. Another one is a right of a reversioner. Under the old Hindu law, the position was like this. A property was being transferred to a woman, would have been given to a woman to enjoy the same for her lifetime. And after her death, the property would go back to the real owner. So that particular person who gets back the property after the death of that lady is called as a reversioner. And that right is a right of reversion. Now, here the person will get back the property only when that woman in whose favor that property was conveyed for her enjoyment during the lifetime dies first. She will have no title over the property. She cannot sell the property. She can only enjoy the property for her lifetime. And after her death, the property will go back to the male holder. Supposing that lady dies first, if the lady dies first, the property will go back to the male holder. If the male holder dies first, there is no question of he getting the property, because the person who has got to succeed on the death of that lady is no longer alive. He is not at all alive. So this is another example of saying a spes successionis. Then second part of clause A of section 6 of the Transfer of Property Act. The chance of a relation obtaining a legacy on the death of a kinsman. We all know that a document will is an instrument by which a person expresses his intention as to how and to whom his property should pass on after his death. So the will come into force only on the death of the testator. So the beneficiary under the will or the legatee under the will not have any right over the property so bequeathed as long as the testator is alive. So the right of beneficiary to succeed the property is contingent upon the death of the testator. Not only the death of the testator, and the second contingency is that that must be the lost will. Because a person can execute any number of wills during his lifetime. So the testator must have predeceased the beneficiary of the will, under the will, and that must be the lost will. Only when these two things are satisfied, then the beneficiary under the will, that the legatee under the will get the property. So this is a chance. He will get a chance to succeed the property only when the testator dies, leaving behind the beneficiary, and the will that is so executed is the lost will. This is the second part of clause A of section 6. Let us move on to the third part. Any other mere possibility of a like nature cannot be transferred. What are the possibilities of a like nature which cannot be transferred? There are some few examples given. They are, number one, possibility of getting prize in a competition. I am going to participate in a competition where the prize amount is rupees 1 lakh. And I am going to get 1 lakh provided I win the competition. So that depends on a future event. Competition must be held. I must participate in that competition. I must actively take part and I must win. These are the contingencies, ifs and buts. Anything may happen in between. The competition which is scheduled may be cancelled. Or I may not be in a position to take part in the competition because of various other reasons like sickness, ill health, or some unavoidable reasons or circumstances, etc. And there is no definite possibility also that I will certainly win. So these are all future events. So now, because I am going to get 1 lakh, if I win the competition, I cannot say to X give me 80,000 rupees loan. I will win the competition and I will get 1 lakh, and out of that I will pay you 80,000 rupees. No, it cannot be done. So that prize money, which is yet to be secured by me only if all these contingencies are fulfilled, cannot be transferred. Number one. Number two, possibility of winning a lottery. I have purchased a lottery ticket of rupees 5 and first prize is 1 crore. So there are so many ifs and buts in between. And finally, I must get a prize. So that is again a chance which cannot be transferred. Future wages of a servant before they actually accrue. I am employed in a company. I have been paid 20,000 rupees a month as my wages. I have yet to work. I have to get salary for October, November, December, which is yet to accrue. And no, I cannot say I will transfer 60,000 rupees to you being the 3 months salary, because the wages themselves has not accrued to me. I have not worked. I don't know what happens in 3 months. I may not go for work, or I may be terminated from service, or the company itself may stop functioning. Anything may happen in between. So my getting 60,000 rupees is depending upon so many contingencies. Therefore, wages that is yet to accrue cannot be transferred. Number 4, contract by a fisherman to transfer the fish which he would get on the next catch before throwing his net. The transfer would be a transfer of mere possibility of the same kind. I have a right to catch fish in a pond. And my average estimation is, in terms of money, the average quantity of the fish that I catch is, say, for example, 5 lakhs rupees. And I am yet to catch fish in the next season. I cannot now agree to transfer that to any other person, because catching fish itself is a future event. There are so many things which should happen in between. There should be a rain, pond should have full of water, fish must be available to us, I should throw a net, I must be all healthy, I should go for work. So there are so many things which are ifs and buts in between. And that is only possible only when all these contingencies are fulfilled and ultimately I throw the net and catch the fish. As on today, I do not have any of these things at my command. Therefore, such a right also cannot be transferred. So, going back to clause A of section 6, which consists of 3 parts. Number 1, the chance of an heir apparent succeeding to an estate. Number 2, the chance of a relation obtaining a legacy on the death of a kinsman. Number 3, or any other mere possibility of a like nature cannot be transferred. In fact, I told you in the beginning itself that I am not an expert, nor I am a good orator. Whatever the little thing that I have read and I have understood and I have analyzed, I am placing before you. Next, B. A mere right of re-entry for breach of condition. A mere right of re-entry for breach of a condition subsequent, cannot be transferred to anyone except the owner of the property affected thereby. A right of re-entry, therefore, is always accompanied by the interest in the land. Mere re-entry, right of re-entry cannot be transferred. Mere re-right of entry means a right to resume possession not accompanied by any interest in the land. This is a mere rewrite of a re-entry. He is only a licensed simpliciter and the personal license cannot be transferred under law. Let us take an example for this. A lets out a house to B. A lets out house to B for a period of 5 years, subject to condition that B shall not sublet it. So subleasing is barred under the contract of lease. But B sublets the house to C. B sublets the house to C. Thereby, he has committed a breach of a condition in the lease deed. So when there is a breach of a condition in the lease deed, I have a right to throw him out and secure re-entry into the premises. This is called as right of re-entry. Now, what clause B of section 6 says is, this right of re-entry is always accompanied with the property. We have a landlord has got a right of re-entry into the house which was let out to a tenant because he has broken the condition of the lease. So the right of re-entry cannot exist independently of the house. The house property and the right of re-entry are one and the same, or will have to go together. Meaning thereby, when I, as a landlord, has got a right of re-entry into the premises because the tenant has broken the condition, I cannot assign that right of re-entry only to C, a third person. Because a right of I cannot ask C, okay, I have a right of re-entry. You go and enter into the property. I can't do it. It is not transferable. Because I am the owner, I have got a right to re-entry for myself. So I have to go and take possession of the property for myself. But take, for example, before the expiry of 5 years, I have sold the property to C. Now, the right of re-entry also goes along with the property to C. Now, when the lease conditions are broken, C will have a right of re-entry. That is the meaning of saying a mere right of re-entry. Please see clause B. A mere right of re-entry for breach of a condition subsequent, cannot be transferred to anyone except the owner of the property affected by thereof. I am the owner of the property. I have leased the property to X for a period of 5 years, and in the lease deed I have stipulated a condition that the tenant should not sublet the property. But he has subletted the property to C. So thereby he has broken the condition. It is only me, as a owner of the property, can exercise that right of re-entry and give it the tenant. I cannot assign that right of re-entry alone to a third person because it is not transferable. But before the expiry of 5 years, that is before the expiry of the lease period, before that period of lease is over, if I have sold the property to a third person, then that third person will become the owner and he will have a right of re-entry because he steps into my shoes. So this is another thing to be understood when we are reading clause B of section 6. Then C. An easement cannot be transferred apart from the dominant heritage. So here it needs some explanation. Section 4 of the Easements Act of 1882 explains what an easement is. The explanation is more wide, more broad, if you look to section 25 of the Limitation Act. Be that as it may. Easement, right of easement can be considered as a right which I have to enjoy on the property of another for a beneficial enjoyment of my property. Let us take, for example, I am the owner of a house. I have a right of way on the land belonging to B in order to reach the main road. So if I want to go out of the house, I have to go on the land of B only in order to reach the main road. Similarly, if I want to reach my house from the road, I have to come all along the road of B only. I am not the owner of that property, but I have a right to enjoy that portion of the land of B only for the purpose of free egress and ingress into my house from the main road. This is the right of easement. I am called as my right is called as a dominant heritage. And B's land is called as a servient heritage. This is easement. Now, I have that right of easement because I have a house there. Independent of the house, I have no right. I can make use of the road, I can make use of the land of B only for the purpose of having an ingress into my house and egress out of my house. So my right to easement goes along with the property. I cannot independently transfer the easementary right alone. Keeping the property within myself, no, it cannot be done. But if I sell my house to X, I will be transferring the easementary right also to X. So the right of easement will have to go along with the property to which it is attached, and it cannot be independently alienated. Let us have a look at that C class C again. An easement cannot be transferred apart from the dominant heritage. So dominant heritage is the house belonging to me. Easement is the right, my right given to move on the land belonging to me in order to reach my house and to come out of my house in order to reach the main road. So I cannot sell the easementary right alone, independent of the property. Easementary right should go along with my house and cannot be isolated. This is another aspect to be kept in mind. Next, number D. All interest in property restricted in its enjoyment to the owner personally cannot be transferred by him. A right is restricted only for the personal enjoyment of the owner. It cannot be transferred at all. So the interest in the property is restricted in the enjoyment to the owner personally. That has been made a non-transferable. Benefits he enjoys in his personal interest cannot be transferred. In fact, it is that interest which is created in that person because of his qualification. A person who is a teacher appointed by the government or appointed by the school authorities, it is his personal right given to him because of the qualification that he has. He cannot transfer that right to somebody else. It is only he who has got to enjoy the benefit of he being a teacher because he has been appointed as a teacher on the basis of his qualification. So the Latin term given to that is res extra camerium, things beyond any trade or transaction. So any right that I have got for my personal enjoyment, which is based on my qualification, cannot be transferred to any other person. A person who is an archak of a temple, appointed for that particular purpose because of certain qualifications that he has, he cannot transfer it to any other person. So like that, an office of a Shabait, Pujari, Mahant of a Mat, Mutawalli of a Waqf, are all restricted interest because they held those posts on the basis of their qualification. Similarly, right in certain lands which are given to a person by way of remuneration for personal service cannot be transferred. All of us are aware that there was Inam Abolition Act, Village Officers Inam Abolition Act, Devadaya Inam, Shanbog Inam, Toti, Talwari, Nirganti, Patel. So those are the lands which were attached to the office of the Shanbog, office of the Patel, office of the Toti, office of the Niraganti, whatever it is under the Village Officers Abolition Act. I'm just giving an example. So the properties are given to them because of the office that they are holding. So they cannot sell those property or transfer those property as long as they are holding that office. Because once they give up that office, the lands also may go, depending upon the provisions of the particular enactment under which the lands have been given to them. So therefore, even all those service tenures also come under this particular category, that is restricted interest. A owner has got a right to sell the property to anybody. He can transfer the interest in the property. But whereas here, though the property is given to those persons, because of the services that they are holding, they have no right to create any interest. They have no right to transfer, and therefore such property cannot be transferred as per the provisions of Section 6 of the Transfer of Property Act. Then, right to future maintenance. Right to future maintenance cannot be transferred because that maintenance is still to be accrued. It may accrue or it may not accrue. The person who is entitled to pay maintenance may be alive or may not be alive. The person who has got to pay maintenance may be alive or may not be alive. Or the order granting maintenance itself may be withdrawn. Therefore, there are so many ifs and buts in between. Hence, right to future maintenance cannot be transferred. Right of preemption. It is a personal right. What is the preemption? Preemption means my right to purchase first, before any other person. A and B are brothers. Let us say, for example, A and B are brothers. They have a house property. They have divided the properties by meets and bounds. So both of them have got half a share each. Now, if A wants to sell his property to, if suppose A doesn't want, he wants to move away from that particular place and he wants to sell his property. He has got a right to sell the property. But the first option, the first right to purchase that property is to the another brother. So he must offer that property to the another brother and ask him whether he is willing to purchase the property or not. And that another brother must be willing to purchase the property at the price which is prevailing in the market as on that particular date. Nobody should suffer a loss. So that preferential right which the other brother has is called as a right of preemption. This is applicable not only in between brothers, in between co-owners. So this right of preemption is a right which cannot be independently transferred. Then, look at clause A. A mere right to sue cannot be transferred. A right to sue for a certain sum of money is actionable claim. If X has to pay me 10,000 rupees together with interest, the amount is certain, rate of interest is certain, calculation can be made by anybody, total amount that is payable by X can be ascertained. That is an actionable claim that can be transferred. But when the amount itself is not certain, total amount payable itself is not certain, then a person cannot, though I have a right to sue that particular person, it is only me who has got to file a suit. I cannot transfer that right to sue to a third person. Take, for example, mean profits. An inquiry has to be held with regard to the mean profits. Actual mean profits has to be ascertained, calculated, computed, and a particular figure amount will have to be determined. Till such time it is determined, it is an unascertained amount. So I cannot transfer my right to sue for mean profits to a third person because it is an unascertained amount. So mere right to sue cannot be transferred. Right to sue for uncertain sum or indefinite sum is not transferable. Right to sue for damages is not transferable because the amount of damages is uncertain. And secondly, it is a personal right. Let us take, for example, A publishes a defamatory statement. A publishes a defamatory statement against B against B. Under law of tort, B has a right to claim damages from A. B think he must sue A claiming 50,000 rupees as damages. But instead of B filing a suit by himself, assigns his right to C. C sues A claiming 50,000 rupees from him for defamation of B. Such right is non-transferable. I'll explain it again. A defamatory article is published by A against B. So it is B who has been defamed. It is B whose estimation in the eye of others is lowered. It is B whose reputation is damaged. So he has suffered loss, damages. So B has got a right to file a suit against A, seeking damages because he has was defamed by A. It is his personal right. He cannot transfer that right to a third person to file a suit against A for recovering damages. By saying that I am entitled for 50,000 rupees, come on, now you file a suit against A claiming 50,000 rupees. That cannot be done. So a mere right to sue is not transferable. So then public office and salary of the public office cannot be transferred at all. This is to ensure the dignity of the office held by a person appointed for the qualities that is possessed by him and getting salary for the due discharge of his public office. A person has been appointed to a public office, could be an officer, could be a clerk, could be a superintendent, could be anybody, a public office. He has been appointed to that particular post because of the qualities that he has, which includes essential qualification and experience also. So because of the qualification and experience that he has been appointed. He has been appointed. When such being the case, it is his duty to keep up with the dignity of the office. Therefore, the law says that public office and salary to the public office is not transferable. It is his personal right. This comes under Section 6, Clause F. Similarly, stipends allowed to military, naval, air force, and civil pensioners of the government and political pensions also cannot be transferred. So these are some of the items which have been made non-transferable, cannot be transferred. So Section 6 of the Transfer of Property Act says, it commences by saying, property of any kind may be transferred except the following. Except the following. transfer opposite to nature of interest, etc. There are certain kinds of interest which are not at all transferable. They are, number one, where the transfer is opposite to the nature, interest created thereby. Example, one cannot transfer the air, light, space, sea, etc. because they are all given as a gift to a humankind by nature. It belongs to everybody. It belongs to everyone on this earth. Therefore, it cannot be transferred. B, where its object of consideration is unlawful. You cannot transfer a property to a person for the purpose of doing something which is unlawful. What do you mean by doing something unlawful? You must refer to Section 23 of the Contract Act. Section 23 of the Contract Act says that no person can carry on a business which is forbidden by law. Number one. If it is of a nature that if permitted, it would defeat the provision of any law. Number two. If it is fraudulent. Number three. If it involves injury to a person or a property of others. Number four. If it is immoral or opposed to public policy. Number five. Let us see the illustrations for this. If it is forbidden by law, I have an agricultural land. I sell the property to B for the purpose of raising opium. It is a prohibited product. Raising opium is forbidden under law. So I cannot sell the property for that particular purpose, nor I can lease the property to any other persons for the purpose of raising that prohibited or forbidden crop. When more so, when neither I have a license nor the person to whom I am transferring is having a license. Second one, if it is of a nature that if permitted, it would defeat the provision of law. For example, transfer of property by an insolvent. An insolvent is a person who is not able to discharge his liabilities from and out of the properties that he has. When such is the case, no person can enter into a transaction with him for the purpose of purchasing the property belonging to an insolvent pending declaration of his insolvency. This is forbidden by law. It is, if permitted, it is opposed to the provisions of law. And third one is if it is fraudulent. So the purpose of purchasing the property itself is to defeat the provisions of the Act, to defeat the creditors. For example, if you read Order 38 Rule 1 and Order 38 Rule 5 of the Civil Procedure Code, you will find that when the defendant is with an object of defeating the rights of his creditor, that is plaintiff, the word used, in order to defraud the plaintiff, he is making an attempt to sell away the property, or he is making an attempt to go out of the jurisdiction of the property. Therefore, we seek for arrest before judgment under Order 38 Rule 1 to 4, or attachment before judgment under Order 38 Rule 5 onwards. So, when the person is about to sell the property only for the purpose of defrauding the creditors, then such a transfer is bad and no person should buy it. Number one, if it involves injury to a person or property of the other. Supposing X agrees with Y and he gives him a contract. You go and kill Z, I will give you this land. So that means a transfer of a particular property is going to be made for as a consideration for doing an act which is unlawful and which is an offense, causing injury to a person or causing damage to the property. You go and lit fire to the house of so-and-so, my enemy, or lit fire to the crop and damage it. I will give you so much. I will transfer my land to you. Examples I am telling. So it is, the intention of transfer is to the consideration for intention of transfer is to cause injury to other person or a property. That is also forbidden under Section 23 of the Contract Act. And it is immoral or opposed to public policy. Letting out the house for the purpose of running a gaming house or running a brothel, they are all immoral purposes, so that cannot be done. So a transfer of property for purposes which are forbidden under Section 23 of the Contract Act also cannot be made. So the sum and substance of Section 6 of the Act is, on the one hand, the Act says that property of any kind can be transferred. And on the other hand, the Act further says, except the following, A, B, C, D, E, F, G, H. So the understanding of Section 6 and Section 5 is very, very important for the purpose of understanding the remaining sections of the Transfer of Property Act. I think with this, Mr. Chatrat sir. Mr. Chatrat sir. Mr. Chatrat. నాకు ఫోన్ కొడు.
Yes, sir. Hello. Sir, you have unmuted, you have muted yourself. Just hold on. So you will have to unmute.
Yes, I have unmuted.
Hello.
I'm unmuted. Can
Hello.
you hear me? Can you
Yes,
hear
sir.
me?
Yes, sir.
Can we stop here? Can we stop here?
Yes, sir. We have few questions on the YouTube, not on the chat.
Yes.
It says, good evening, sir. With whether readiness and willingness to perform regarding the balance consideration amount, or is it regarding the balance consideration amount plus stamp duty and registration charges amount?
We have not reached that particular stage at all.
Okay, sir.
Let the questions be confined to Section 5 up to Section 6.
Right, sir. So these are all in general also. Except one Satyanarayan says an excellent session. Perfect session. Pradeep Thakur says very informative session. Anita Bafna says very good session. So everybody has acknowledged your insights, and we are also thankful for sharing your knowledge.
Thank you very much, sir. Thank you.
The Gandhi Jayanti and Lal Bahadur Shastri's birthdays couldn't have been celebrated in a much better way. The way you have transferred your knowledge to us. Thank you. Jai Hind.
Thank you very, very much. All the very best.